types of deposit accounts. So we will be covering the different type of account. First of all, it is related to the individual accounts. So section 11 of the Indian Contract Act 1872 says that every person who has attained the age of majority, who is of sound mind, who is not disqualified from entering into any contract by any such law, he is not insolvent, and further is not resident of enemy country, basically he can enter into any contract and can open the account. And even though the minor which is having no capacity to enter into any of the contract, under the section 26 of the Negotiable Instrument Act, under the section 26 of the Negotiable Instrument Act, the minor is permitted to open the deposit account with the bank itself. So the minor person can also open the deposit account with the bank itself. If the minor is aged below 10, in that case the account can be opened with his or her natural guardian, and in case if the minor is 10 years or above, in that case the minor can also open self-operated minor account. Self-operated minor account can also be opened. Otherwise, the section 11 of the Indian Contract Act 1872 says that any of the person who is competent to enter into the contract, who's basically has attained the age of majority, is of sound mind, and is not disqualified from contracted by any law, he is not insolvent, and further is not residing or resident of any of the enemy country, can enter into the contract. Okay, so that is regarding it. Then it is regarding the joint accounts. So now single person can open the account, and jointly the accounts can also be opened. Likewise, A and B are two friends. They want to open the joint account. Is it permitted? Definitely it is permitted. They can open the joint account. There can be the different account authorities. First of all, it could be regarding they will be jointly operating the account. In that case, signatures of both the customers are required. It could be the case that the account operations are either or survivor, that either of the person can operate the account. It could be the case of former or survivor. If the first person is A, then A is former, B would be survivor after the A is deceased. Okay, so basically in that case, A will be operating the account, and after the death of A, B will be operating the account. Okay, so these are basically the different operations in the account itself. So kindly please change the resolution of the video so that the screen would be working fine, because otherwise the internet connection speed is working very fine at our end. Okay, so two or more persons who are competent to enter into the contract, they can open a joint account. And further, the operational instructions must be clear so as to operate the account. That is regarding including for payment of the balances and other things. Then it is regarding the HUF. Then it is related to the HUF, that is a Hindu undivided family. So HUF or GHF, that is joint Hindu family, is not based on any of the acts. It is not a separate legal entity. So Hindu undivided family, HUF, is not a separate undivided family. And further, the share in the ancestral property is decided on the basis of the Hindu Succession Act. So based on the Hindu Succession Act, the share in the ancestral property is decided. So HUF is managed by the eldest male or female member of the family. So previously it was a male member only. Previously it was regarding the male member only, that only the eldest male member can be the Karta. But after the latest amendments of the Hindu Succession Act, the female members of HUF enjoy the same rights as that of the male members. Now the eldest female member can also become the Karta, which was previously not true. But now after the amendments, the female eldest member can also become the Karta of the family. Okay, so now let me tell you about it. So now there is a ancestral property of family ABC. Family ABC is there, Sharmas or Guptas or whatever family it is. Okay, and further they are having a common ancestral property. Let us say there are different persons in the family itself, like A, B, C, D, E, F. Okay, so these are different persons in the family, and A is the eldest. Whether he is male or female, A would be the Karta of the family. And it means that A would be having all the powers that to execute so as to take loan based upon security of this property itself without any of the interruption of any of the other members. And the other members are said to be the co-partners. These are said to be co-partners. Okay, now let us further move. Then it is regarding there are no restrictions on the number of co-partners. There are no restrictions on the number of co-partners. Co-partners can co-partners can be unlimited. Co-partners can be unlimited. And further, one co-partner is not an agent of another co-partner. One co-partner is not an agent of the another co-partners. Now have a look at the powers of Karta. What are the different powers of the Karta? So as per law, Karta has the powers to incur the debt. Karta has the power to incur the debt, and further Karta can execute the documents so as to pledge the securities on behalf of the family business. And for that purposes, the consent of co-partners is not required. Karta can manage the estate of the family without any interruption without any consent of the co-partners. And further, the liability of Karta is unlimited. Karta is the unlimited liability. What do you mean by unlimited liability? It means Karta's share in the family is also liable, and also his personal assets would be liable. Karta's share in the family business, family property is liable, and also his personal assets are liable. Karta's liability is unlimited, whereas the liability of co-partner is up to the extent of the share in the HUF property. Okay, their property is only limited to the share in the HUF property, but the liability of the Karta is unlimited. Then it is regarding if the documents are signed by co-partners, only then they can be made personally liable. There is a very important point. So whenever a loan is extended by the bank to HUF, in that case, bank basically Karta can only itself has a power so as to incur the debt. He can basically take the debt itself, but bank for security purposes, because the co-partners are not personally liable, so bank for security purposes get the documents executed from all the major co-partners and the guardians of the minor co-partners. It could be the case there could be minors also. In that case, the documents are to be executed by the Karta and all the co-partners and minors guardians. Okay, and once the co-partners have executed the loan documents, they will also be becoming personally liable. So what are the precautions while granting credit facility to HUF? What are the precautions that must be taken? So whenever loan is to be granted to HUF, the bank should ensure that the credit facility is for legal necessity of the HUF. It must be ensured. And further, all the loan documents, as I already told you, all the loans documents must be executed from the Karta and all the major co-partners and guardians of minor co-partners should also be executing the documents so that they can also becoming personally liable. Otherwise, only Karta is personally liable, or Karta is having the unlimited liability. Co-partners do not have unlimited liability. They have already liable up to the extent of their share in the HUF property. So as to make them personally liable, the documents are to be executed by them also. Okay, when the documents are executed by the Karta alone and not by the co-partners, HUF property is liable and Karta is personally liable only, and co-partners are liable only for their share in the HUF property, and the co-partners are not personally liable. So as to make them personally liable, documents are executed by the major co-partners and guardians of the minor co-partners. Okay, that is regarding it. Further, it is regarding if Karta stays abroad most of the time, he continues to be Karta. It cannot be said if Karta is staying abroad, it cannot be said another person would be becoming Karta. Karta would remains to be Karta. Continues to be Karta for operating of the account. He can give mandate to any of the person. He can give mandate to any of the person. It could be any of the co-partners, it could be some outsider also. Okay, and further, a co-partners cannot countermand the checks unless the Karta has delegated the authority to operate the account. Very, very important. So if a check is drawn by Karta, it cannot be countermanded by any of the co-partners until or unless Karta has delegated the authority to operate the account to that particular co-partner. Okay, and as per the Supreme Court decision, HUF cannot become a partner in partnership firm because HUF is not a legal entity. It is not a legal entity and it cannot become partner in the partnership firm, whereas company, which is a legal entity, can become partner in the partnership firm. Are you getting my point? Okay, so that is regarding it. Next it is regarding the minor. So section 3 of the Indian Majority Act 1875 says, so every person who is domiciled in India will become major on completion on age of 18 years. So if any of the person is below 18 years, he is minor. And as per the Indian Contract Act 1872, minor is not capable of entering into any of the valid contract. And further, if any of the contract is being entered by the person, in that case, that is void ab initio. In that case, that would be void ab initio. And further, a contract for supply for the necessities of the life to a minor is, however, a valid contract. So if you are entering into any of the contract with the minor itself so as to supply the necessities, of the necessities for the life of the minor, that would be a valid contract. Otherwise it is not. Then it is regarding, in case other contracts, a minor may repudiate his promise or his consent. Now let me give you a case study based upon it, and you will be giving the answer regarding it. Okay, so person A is a minor. Over here, and further person G, which is a very reputed party in your bank, he basically visits your branch XYZ over there and asks to grant a loan based upon the guarantee of person G. So G is ready to give a guarantee. For sake of extending a loan to minor G. In that case, who would be responsible if after sanctioning a loan to the minor, minor refuses for paying it back? If minor refuses for paying it back, minor defaults, in that case, who will be responsible? Can bank ask for the money to the guarantor? Can bank basically go legally? Can bank sue legally guarantor over there or not? Okay, so kindly please answer it first. So A is extended a loan on the guarantee, based on the guarantee of person G. A defaulted later on. Can bank sue G over here or not? Because bank cannot sue minor, we already know, because that is basically contract is void ab initio. Contract with the minor is void ab initio. Okay, can bank sue guarantor or not? What would be the answer in that case? That case study has already been asked in the exam itself. So you need to answer this question. We have already covered that particular point. You need to understand. So let me tell you, any of the contract that is being entered by any of the person with the minor is void ab initio. Void ab initio means it will not be valid from the very start, from the very beginning. Okay, so in that case, if the main part of the agreement based upon which the guarantee was given, that is also invalid, and all of the loss is to be borne by the bank itself. It will be borne by the bank itself. Are you getting my point? Okay. And also the case, minor person A is a minor, visited your branch and he asked for a demand loan. He is maintaining a fixed deposit account of rupees 10 lakh. He is maintaining a fixed deposit account of rupees 10 lakh with your bank, and he asks for a demand loan based upon this FDR. Can you extend a overdraft or demand loan to the minor? Can you extend the overdraft facility or demand loan facility to the minor? Yes or no? Yes or no? Kindly do answer it at the earliest. Can the bank sanction a loan over there? Security is available. Security is available. Can you sanction the loan to the minor? No, you cannot sanction the loan to the minor. If you sanction the loan to the minor, even based upon the security, that would be void ab initio. Minor can sue the bank. Minor can sue the bank. Bank would be held liable in that particular case. Okay. So it is only permitted that minor can operate the account, minor can draw the check, minor can basically endorse the instrument under the section 26 of the Negotiable Instrument Act. But any of the contract entered by any of the person with the minor itself would be void ab initio. So RBI has allowed the minor to open the self-operated deposit account provided he has completed the age of 10 years and is literate. What do you mean by literate over here? Literate means that he can sign in his own, that he can sign. And further, very important point, two minors can also open jointly operated deposit account. Two minors can also open jointly operated deposit accounts if they have completed the age of 10 and further they are literate and are belonging to the same family. In that case, two minors can also open a jointly operated deposit account. Then it is related, accounts can be opened in the name of the minor to be operated by his guardian or guardian appointed by the court. So there are three types of guardian. First of all, it is a natural guardian. So in case of Hindu minor, natural guardian is either mother or father. Both are basically natural guardian. And further, if the guardian is appointed by court, then it is said to be the legal guardian. And if guardian is appointed by the will of the father, it is said to be the testamentary guardian. It is said to be the testamentary guardian. And account can be opened in the name of the minor, which can be operated by his guardian. And further, on attaining the maturity, there is no need to close the account. So if A, who is a minor and 16 years old, open an account with the bank itself where G is the guardian, after attaining the age of 18, the previous account is not need to be closed. Person A would be basically disclosing the identity. Person A over here would be visiting the branch, will be submitting the KYC, and further a new AF would be signed and the previous account would be converted to the self-operated account of the minor, and for that purposes consent of guardian is not required. The consent of guardian is not required. On attaining majority, there is no need to close the account. I already told you. So there is a question regarding if guardian is present, then can we give loan? Definitely. In that case, the loan facility can be extended. And further an undertaking would be taken from the guardian itself that money disbursed, amount disbursed would be used for the betterment of the ward, minor itself. Okay. And further, RBI on the basis of the Supreme Court judgment has allowed mother to operate all types of accounts under all system of the personal law, even though the father is alive. So we can say both father and mother are natural guardians. And after the death of both, the guardian is to be appointed by the court itself. That is said to be the legal guardian. In case minors is above 10 years and he is having self-operated account, in that case nomination is not possible. In minor self-operated account. Okay. And further, in case the minor dies, the balance in the account will be paid to the legal heirs of the minor. So if A is minor and he is basically operating a self-operated account, in that case nomination facility is not available. And for that purposes, if A dies, in that case the balance in the account would be paid to the legal heirs of the minor. And in case joint account means if A is having a guardian operated account, If A is a minor and he is having a guardian operated account, in that case, if minor dies, G would be basically managing the balances. And further, no overdraft or loan can be granted to the minor even if security is provided. Okay. And further, it is regarding according to section 26 of the Negotiable Instrument Act. According to the section 26 of the Negotiable Instrument Act, a minor can draw or endorse of negotiable or a check or a bill, but he cannot held liable for such a check or bill. So as I told you that a checkbook facility can be given to the minor itself, but with some safeguards. So now what is the safeguard? That on each of the leaf, that on each of the check leaf, you will be mentioning minor's account. You'll be mentioning minor's account. So if A has given a check, A basically drawn a check and further given it to person B, and B basically endorsed that check to person C. B endorsed that check to person C, and C presented that check to the bank. C presented that check to the bank and the check was dishonored. In that case, C can held B liable but cannot held A liable. Because A is a minor over here. He has the right so as to draw the check, so as to endorse the check, so as to negotiate a check or bill, but he would not be held liable. He would not be held liable if the instrument is dishonored. Okay. Further, a minor can be admitted to the benefits of the partnership firm with the consent of other partners. That is covered under section 30 subsection 1 of the Partnership Act. Now, what is a partnership? What is a partnership firm? So if there is an association of 2 or more persons, let us say A, B, C, 3 persons are there, who basically are working for a common goal, for common profits, and it is a partnership firm. In the case of the partnership firm, the partners are having unlimited liability, and further, a minor can be admissible to the profits of the firm. As I already told you that a minor cannot enter the contract, and contracts entered by the minor with the minor are void ab initio, and in that case, D, who is a minor, he cannot basically become a partner of the partnership firm, but he can be admissible to the partnership firm for the profit purposes with the consent of all the partners. In that case, the liability of the minor would be only up to the extent of his share in the partnership firm's property. Okay, it would be only and only up to the extent of the minor's share held in the partnership firm. Okay, and further, if minor has attained the majority, on attaining the majority, he will be having two options. That first of all, he wants to be partner, he continues to be partner. Let me write over there. Yes, that I want to continue to be a partner. Okay, that is the first case, and the other case it is that he do not want to continue. He do not want to continue as partner. Okay, now in all the cases, after attaining the majority, once D has attained the majority, so D was admissible to the profits of the partnership firm when he was aged 13 years. And further, now he attained the age of 18 years. Now particularly, he is having two options with him, that he can continue to be partner of the partnership firm, and secondly, he says that he do not want to continue as a partner of the partnership firm. And now, after attaining the majority, within a period of 6 months, you need to remember this because it is a very important point. Within 6 months, he is to give a public notice. Regarding the same, regarding his choice that he wants to continue or not. If he chooses that he do not want to continue, as partner, in that case, let us say that he attained majority on 1st of January 2021. He attained majority on 1st of January 2021, and further he gave public notice on 31st of March 2021. He gave public notice regarding that he do not want to continue as a partner in the partnership firm on 31st of March 2021. In that case, his liability would be only for those agreements which were signed by the partnership firm up to 31st of March 2021. That is up to the date of the public notice, and after that date the minor cannot be held liable for any of the acts of the partnership firm. Okay, so any of the acts which were basically done by the partnership firm from the age that he entered, that he was admissible to the profits of the partnership firm, to the age that he has given the public notice, he can be held liable for those acts. But after that all the agreements which are signed by the partnership firm, he will not be liable because he has given the public notice in same regard. Okay, but in the second case, if he do not give any kind of public notice, it would be taken that he wants to continue to be a partner. If he has not given any of the notices, the public notice in the 6 months period, it would be taken that he basically wants to continue as the partner in the partnership firm, or either the case that he has given a public notice that he wants to continue, both would be the same. Okay, and in that case his liability would be from the date he entered to be admissible to be the profits of the partnership firm. His liabilities would be from the date he was admissible to the profits of the partnership firm, and he will be now continuing as a partner of the partnership firm. Okay, so that is the point regarding it. Then it is regarding minor cannot give stop payment instructions in the partnership account. So if a minor is admissible to the profits of the partnership firm, he basically cannot countermand the check, he cannot give the stop payment instructions of a partnership account, but he has every right so as to demand the statements of the account. So if he visits the bank and asks for the account statement of the partnership firm, in that case after verifying the identity of the minor, the bank is having the obligation so as to give the statement of the account. And further, a minor may be appointed as an agent to act on behalf of his principal. A minor may be appointed as an agent to act on his behalf on his principal, but legally he cannot be held responsible to his principal as well as the third parties. Very, very important. Now in case person A is a principal and he has given a mandate to person B who is a minor so as to act on his own behalf. So A is a principal and B is agent in this case. So if any of the duties of any of the activities are being performed by person B and these activities were in person D was also involved, so in that case activities are performed by person B, but B will not be held liable to any of the third parties and also not to the principal. Okay, and further we have already learned it, in case a self-operated account, if minor dies, the amount would be paid to the legal heirs. That would be a claim case. Okay, and it is regarding the very, very important, that is regarding the natural guardian of minor. So in case of Hindu, father, and after the death of father, mother of minor are basically the natural guardian. And regarding the married Hindu minor girl, who will be the guardian? His major husband would be the guardian. And in case husband is also minor, in that case husband's father, that is his father-in-law, would be the guardian of the married Hindu minor girl. And widow Hindu girl, in case of a widow Hindu girl where husband is died, in that case guardian of the husband, that is father-in-law or mother-in-law, would be the guardian of the widow minor Hindu girl. And minor with stepfather, in that case first priority is given to mother and after that her father. Then minor with stepmother, in that case first priority is for father, after that her mother. And in case of Muslim minor, father would be the guardian, and after the death of a father, his executor, so executor of the father's will would be the guardian except mother, and after him father's father, that is a grandfather, would be the guardian of the Muslim minor. Okay, so you can take a screenshot of this because many times the questions are directly asked from this table itself. Then it is regarding the trust accounts. So no bank account of public trust can be opened. So there are two type of trust: public trust and private trust. In case it is a public trust, no account cannot be opened without taking the registration certificate which is issued by the charity commissioner. In case of public trust, it must be registered and registration certificate is issued by the charity commissioner. And for private trust, registration is optional. In that case, registration is optional, but for the public trust, registration is mandatory. And in case of trust, basically there is a trustee. And there is a very important document, that is a trust deed. And based upon the provision of a trust deed, the account is being operated. So if any one trustee dies, the provisions of trust deed will operate. So there may be the case that there is only sole trustee, it may be the case there are multiple trustees, and in case any of the trustee dies, the provisions of the trust deed will operate. If the sole trustee dies, the further operations of the account will be stopped. And the check already signed be paid. What does it mean? It means if A was the sole trustee of the trust, and A dies, in that case the account operations are to be stopped. And further, if A died on 15th of March 21 and he signed a check dated 12th of March 21 and that particular check is presented, it is to be honored. Okay, it cannot be dishonored in the case that the person died. But in the case of individual accounts, what happens? If person A signed a check on 12th of March 21 and further he died on 15th of March 21, the same check was presented on 18th of March 21. Is it to be honored or not? What would be the case? Regarding this? In the case of individual person we are talking about over here, that he signed a check, he drawn a check on 12th of March 21, died on 15th of March 21, the check was presented 18th of March 21. Is it to be honored or not? In the case of individual account, no, it is not to be honored. It cannot be honored because the banker customer relationship ceased. There is cessation of the banker customer relationship in that particular case, so the check should not be honored. In that particular case if it is in the knowledge of the bank that the customer has died. If the customer has died and it is in the knowledge of the bank, in that case it should not be honored. Okay, but in the case of trust, if the trustee has signed the check on 12th of the March and later on he dies and later on the check was presented, it is to be honored. Okay, because the trustee was not acting in his personal capacity. He is basically acting in the capacity of the trustee. Okay. Further, the stop payment instructions for the check can be given by any trust member, including those who is not authorized to operate the trust account. So in the case of trust account, the check stop payment instructions can be given by any of the trust members, including those members also who are not authorized to operate the trust account. Okay. Further, it is regarding trustee cannot delegate his powers until it is provided in the trust deed. It is not the case that trustee is given some powers and further he can delegate those powers. That cannot be done except the case if it is specifically provided in the trust deed. And further, regarding the power to borrow, trustees cannot borrow until or unless it is specifically provided in the trust deed. And trustees if the trustees on the death of the trustee or insanity or insolvency, checks issued by the trustee will be paid if otherwise in order. That we have already covered. That point we have already covered. Okay. Next, it is related to the partnership firms. So partnership firms are governed by the Indian Partnership Act 1932. Partnership firms are governed by the Indian Partnership Act 1932. And further, regarding the minor, we have already covered the point that minor cannot be the partner of the partnership firm, but minor can be admissible to the benefits of the partnership firm with the consent of all the partners, and he will not be personally liable, but his share in the property would be liable. So minor himself will not be liable, but his share in the partnership firm would be liable in that regard. Registration in the case of the partnership firm is not mandatory. It is not mandatory. Registration is not compulsory. And if it is to be done, it is to be done with the registrar of firms. And very importantly, banks normally do not grant any kind of the credit facilities to those partnership firms which are not registered. Why so? Because the firms which are not registered cannot be sued, and they cannot sue the third parties in their own name. So if a firm is not registered, they cannot sue the other party, and the other parties cannot sue the unregistered firm. Okay, so that is why banks do not grant any kind of the credit facility to the unregistered firms. And regarding the number of partners, what is the minimum number of partners in the partnership firms? Minimum number of partners is 2, and the maximum number of partners is 100 as per the Companies Act. So as per the Companies Act, it says if the number of partners in any of the association, in any of the partnership firms exceed 100, in that case that particular partnership firm would not be valid. That is why as per the Companies Act, the maximum number of partners is now restricted to 100. Further, that point we have already covered, that HUF Hindu Undivided Family is not cannot be a partner because HUF is not a separate legal entity. But company is a separate legal entity, and that can become member of the that can become the partner of the partnership firm if that is permitted under the Articles of Association. So Article of Association and Memorandum of Association, both of these are very important documents regarding the company. Okay, so Article of Association is related to the internal bylaws and rules, whereas Memorandum of Association is basically related to the overall objectives of the firm and how the firm will be dealing with the outer world. Okay, then it is regarding the section 19 subsection 1 of the Partnership Firm Act. So acts of a partner to carry the business of the firm is a usual way bind the firm. So partner is basically the agent of the firm. So let me give an example. If A, B, C are 3 partners in the partnership firm, first of all, the liability of each partner is unlimited. Liability of each partner is unlimited. Okay, and further, if any of the act is performed by any of the partner, in the normal course of business, in that case, act of the partners would be binding the firm itself. Okay, then as per the section 18 of the Partnership Firm Act, every partner is the agent of the firm. And act of partner is known as the act of the firm. That is known as implied authority of the partner. So there are some exceptions contained in section 19 subsection 2. So there are many of the authorities, implied authorities which are given to the partner itself, which are related to the normal course of business. But if you want to open an account, that is not the normal course of business. Normal course of business is basically related to, likewise, if ABC partnership firm is related to the sale purchase of furniture, if person A, that is partner A, purchase raw material for furniture purposes, that would be basically normal course of business. If he is selling the furniture, that would be normal course of business. But opening the account would not be the normal course of business now, and also closing the account will not be normal course of business. Or it could be related that a mortgage has been created, a charge has been created on the property of the partnership firm. That is also not a normal course of business, or related to giving some guarantee or entering into some compromise, filing the suit, acknowledgement of the liability, withdrawal of suits. So these are basically some of the examples. These are basically some of the exceptions which are not related to the normal course of business. Okay, so these are exceptions under the section 19 subsection 2. Then it is regarding the very important point that if person A, there is a partnership firm ABC, and person A issued a check. Can the check be countermanded by the partner B or C also? Can the check be countermanded by the partner B or C also? Can you please let me know? kindly please let me know at the earliest. A, B, C is a partnership firm, and B, can person B or C can also countermand the check? Yes or no? Simple it is. A, B, C are three partners over there, and A has issued a check. Can the check be countermanded by the person B or person B also? Yes or no? So let me tell you, B or C can countermand the check. They can stop payment. They can give the instructions for the stop payment of the check. They can give the instructions for the stop payment of the check. Even if C is a sleeping partner, is not an active partner, is not involved in the business activities, even also he can give the instructions for the stop payment of check. And if the status of the check is to be reinstated, let us say now the check is stopped payment, now the stop payment instructions are given. Countermand means stop payment instructions. Okay, now if the check is stopped payment, and further the status of the check is to be reinstated, in that case all the partners are to sign jointly on the mandate. In that case all the partners are to sign the instruction form, so as to reinstate the status of the check. So after a single partner can give the stop payment instructions, but if the check is stopped payment now, and for reinstating the status of that particular check, all the partners will be signing the instruction form. Okay. Then it is regarding the new Companies Bill 2013. So there are two type of companies: private limited company, public limited company. So first of all, let me tell you regarding the company itself. We have already gone through the basics, so I'll not be explaining it again. So minimum number of members in case of private limited company is 2. Maximum members it is 200. In case of public limited company, minimum member is 7. And for the public limited company, there is no limitation on the maximum number of members. If we talk about the directors, in the case of the private limited company, the minimum number of directors is 2 and maximum number of directors is 15. And further, for the public limited company, the directors are minimum number is 3 and maximum number is 15. That can also be basically there can be more directors by way of some special resolution. And further, it is regarding, there are two important documents I already told you. One, it is a memorandum of association, other it is the articles of association. So memorandum of association is basically that how the company would be establishing the relationship with the outer world. So the company related objectives, what is the purpose of the company, the expressed purpose, these are all expressed in the memorandum of association. And further, if any of the activity is performed beyond the scope of the memorandum of association, that is ultra vires. That is basically ultra vires. Okay. Then further, it is regarding the articles of association. Articles of association is basically the bylaws related to the internal function of the company itself, internal regulations of the company itself, that how the employees would be working, would be the working criteria, and all the things would be covered in it. And further, if any of the act is done beyond the scope of the articles of association, that would be intra vires. Now what is COI? COI is a certificate of incorporation, that is a date of birth certificate of the company. So it is issued by the registrar of companies. I have already told you that registration of the company is mandatory. And it is issued by certificate of incorporation is issued by the registrar of companies after the company has been registered with it. So the legal existence of the company begins from the date of issue of certificate. And in the case there is a death of director, I told you that the ownership and management in the case of the company is different. So management is with the board of directors, where there are different directors. So if one director dies, in that case your company would be existing. It is having the perpetual existence. Okay. And even if a check is assigned or authorized by the director who has died, is presented after his death, that is to be honored. And it is regarding the conversion. What do you mean by conversion? So if a check was in the name of company XYZ Limited, and that was basically credited to the director's account, that would basically amount to conversion under section 131 of the Negotiable Instrument Act. That would be basically amount to conversion under section 131 of the Companies Act, of the Negotiable Instrument Act. Then it is regarding the one-person company. In case basically the person is only one person is there so as to operate the work. He do not want to go for the proprietorship firms due to the liability, unlimited liability. One person company can be formed. Okay, so in case of one person company means a company which is having only and only one person as the member, and he can nominate and one other person, and one person can open only one person company. Okay, so if person A has having Pico Private Limited company as one person company, then A cannot create any other one person company. A cannot open any other one person company. And further, only a natural person who is Indian citizen, and further resident can set up the company. Okay, so only and only a natural person and who is a citizen and resident of our country can open the one person company, and also only and only a natural person who is a citizen, who is a resident can become the nominee of the OPC, and further OPC is meant for very small businesses, as I already told you. In case OPC, Memorandum of Association, should state the name of the person and who in event of death of the subscriber shall become the member of the company. Means the nominee would be becoming the member of the company in case of the death event of the concerned person. Okay, then it is related to the societies and clubs. So societies are generally incorporated under Cooperative Societies Act. These are basically incorporated under the Cooperative Societies Act, and these are having entity only after their incorporation. So it means when they are registered, only then they are incorporated. And further, clubs are registered under Societies Registration Act. So you need to note it down. Societies are incorporated under the Cooperative Societies Act. Clubs are registered under the Societies Registration Act or the Companies Act. And further, these are basically, both societies and clubs are basically associations of persons, or it could be non-profit making organizations, So purpose of these could be related to the promotion of art, literature, etc. Purpose of forming these associations is can be related to the promotion of art, literature, etc. And if we talk about the banking operations, for opening of the account, copy of registration certificate is to be obtained, copy of rules and regulations. So whatever deed is over there, it is to be obtained. Copy of resolution passed by the managing committee of the trust, managing committee of the society or club is to be obtained. And further, the deed or resolution will be specifying that what person would be authorized so as to operate the account and what would be the conditions so as to operate the accounts. And the documents, documents are to be obtained. So these documents are to be obtained. That is regarding the copy of registration certificate, copy of rules and regulations, copy of resolution passed by the managing committee, which will be authorizing the members so as to operate the account, and the conditions regarding it. And regarding the sanctioning of loan, this is to be ensured the purpose of the loan is consistent with the objective of institution. Okay, so the purpose should be consistent with the objective of institution, and further the amount of the loan is within the borrowing capacity of the association itself. Okay, in the event of the death of the authorized person, the account is to be operate, which were basically operating the account. The account operations are to be stopped in another bearer is authorized for the same. So if person A and B were authorized jointly to operate the club account and A dies, in that case the account operations are to be stopped till a new bearer is assigned. So if person C was assigned in place of person B, then B and C would be able to operate the account. Okay, till then the account operations are to be stopped. Okay, further it is regarding the cooperative societies. So cooperative societies, voluntary association. Cooperative society is basically a voluntary association which is basically aiming to provide the services to the members. So what is a cooperative society? So society is formed where there is association of different persons. So one, it would be the managing committee. There would be managing committee who would be managing all this society, and further it would be basically started with the aim of servicing for providing the services to the members. Likewise, cooperative society is there so as to sell the cultivations. Okay, in that case also, that is a society itself. So it is a form of business where individuals belonging to the same class join their hands for the promotion of their common goals. Okay, so a common association is there, association is there for the purpose of common goals. They want to promote their common goals. It is compulsory for the cooperative society to get registered. It is compulsory for the cooperative society to get registered. Okay, and further, it does not affected by the entry or exit of the members, because if it is registered, it is a separate entity. It is not affected by the entry or exit of the members, and there is limited liability of the members of the cooperative society up to the extent of their amount contributed by the members, and I already told you that there will be a managing committee who will be having powers to take the decisions, and the members will be having the right to vote. They can elect the members that who will be constituting the managing committee. So the managing committee members would be decided among the members after the voting process. Okay, and the cooperative society works on the principle of mutual help and welfare. Okay, further it is regarding the account operations. If we talk about the account operations, the account can be opened with the cooperative banks, commercial banks, with the permission from the registrar of cooperative society. So it is to be registered with the registrar of cooperative societies. And banks can also open the accounts of unregistered clubs or institutions, societies, associations, schools after satisfaction about their reputation and responsibilities and standing of the office bearer of such bodies. So even if these are not registered, it is not so the account cannot be opened. For reputed schools, clubs, associations, the account can be opened, but no lending is to be made to the unregistered bodies, because you cannot sue the unregistered body. Further, in the event of the death, resignation of the authorized office bearer, the account operations will be stopped until the nomination of the another. And further, if the checks payable to such bodies, even if endorsed, collected for personal account. So if there was a ABC club, and the check named in this club was basically deposited in the personal account of person A, that would be basically conversion. That will basically amounting to conversion under section 131 of the Negotiable Instrument Act. Now, let me just tell you, there are a lot of instruments that are being used right now by the customers over there, whether it is a check, draft, pay orders, or the trade bills over there. And further, they are payable or maybe payable locally, and further are also payable at outside centers over here. Okay. Now, the instruments which are actually payable locally are actually collected through the local clearing houses over there, or clearing housing systems over there. And the instruments which are payable outside are sent by the banks for the collection purposes. Like we are having bank A over here, and let's say an instrument is to be basically collected outside, it will be sent for collection purposes. And further, if it is to be cleared locally, it will be cleared using the local clearing house system over there. Okay, so interbank transactions among the local banks are settled by the clearing houses over there, and there can be also be a separate clearing house for the MICAR based and for the non-MICAR instruments. That MICAR is what? MICAR is magnetic ink character recognition. So in this particular unit, we are going to read all in detail about the CTS and the other clearing systems over there. Okay, so now let's start with the electronic clearing services, that is ECS over here. Now, first of all, let me tell you that clearing houses whatsoever are there are actually managed by the Reserve Bank of India, State Bank of India, and any other bank which is nominated by the Reserve Bank of India. And particularly when we talk about the ECS, it's like we want to clear a multiple instruments over there, like the objective would be the same enough. So we are having the two categories for the ECS. One, it is the ECS credit, and the other one, it is the ECS debit over there. Now in this case of ECS credit, particularly there will be a single receiver of funds. Okay, the persons want to pay the utility bills. In that particular case, the customers are numerous. We are having thousands of customers, and they want to pay to the same company over there. In that particular purpose, the multiple accounts will be debited, and further the single account will be credited over there. Okay, that is actually the purpose related to the ECS credit over there. And when we are talking about the ECS debit, in that particular case, it is totally opposite, that there will be only single account that will be debited. Like a company wants to pay the dividend to the customers or the holders, shareholders over there. In that particular case, only company's account will be debited. That is a single account that will be debited, and the multiple accounts of the shareholders will be credited with the dividend over there. I'm just giving an example related to that so that you can just relate to it and further can memorize the thing over there. So in case of ECS credit, there is single credit, and further in case of the ECS debit, there is a single debit and multiple credits over there. So that's related to ECS debit and ECS credit. Then the next topic, it's related to CTS. Now what is CTS? It is a check truncation system. So truncation is a process related to what? When there is the stoppage of the physical check over there. Like in previous cases, what happened actually, that the check was actually moving from one place to another, and then it was cleared over there. But now what happens, that the physical check is not moving over there, but only the electronic image of the check is obtained, and further that is actually sent for clearing purposes along with the other details. So we will be learning in detail that what is CTS and what are the different components of it. Okay, so the truncation is the process of stopping the physical movement of the check over there, and instead of that, an electronic image of the check is actually transmitted along with the required information. It could be related to the relevant information of the check over there, it could be related to the micro code, it could be related to the date of presentation, presenting bank over there, etc. All the details are being sent over there. Now particularly the Negotiable Instrument Act 1881 defines a truncated check as a what? It defines a truncated check as a check during the course of clearing cycle when the physical movement of the check is truncated, and further only the electronic image is transmitted over there, and further based upon that the bank actually clears the payment and the account is settled over there. That's actually related to the truncation of the check over there. Okay, now with that particular regard, there were a lot of sections, there were a lot of articles and further acts over there which were actually amended so as to give effect to the CTS check over there. Like the NI Act 1881 was amended, IT Act, Information Technology Act 2000 was amended, and further the Bankers Book Evidence Act 1891 was amended, and also that gave the legal framework to the CTS over there, and e-checks was put in place in 2002 over there. Okay, so CTS was actually introduced in the banking system from February 1 and 2008, and it actually is now fully operational over there, and micro based check processing has been discontinued because it was too much time consuming. We basically want to reduce the clearing cycle over there. That is why the CTS is introduced. Okay, and CTS is operating actually in grid basis system. Now what is actually grid basis system? That the whole country is actually divided into 4 grids. Like we are having the north grid, south grid, and for the east grid and west grid over there, and based upon that actually the clearing system does takes place, and further the check can actually be cleared using the local clearing houses on T+1 basis now. Okay, and further as per there we know that there are a lot of number of checks actually which are not CTS, that is known CTS checks are there. For that particular purpose there is a separate clearing that is taking place over there. Okay, and RBI decided from November 1 2014 that these checks will be presented, like whatsoever the known CTS checks will be there. It was decided that from November 1 2014 all those known CTS checks will be presented for payment on every Monday, and further if the Monday is a public holiday, on that particular case on previous working day the clearing of the known CTS will take place. Okay, and further the drawings banks will return the known CTS 2010 standard instruments presented in the regular CTS clearing. Like if there is a CTS clearing and further the known CTS check was presented for clearing in the CTS clearing, in that particular case the code 37, that is the payment in proper zone, will be given as a note on the memo and it will be returned. Okay, that's actually related to it. Now let's understand the characteristics of the CTS first of all. Now as I told you that the physical movement of the check is actually truncated and only the electronic image of the paper check is taken and further that is transmitted. So only the bank involved in the clearing house can truncate the check over there. None other than the bank can actually truncate the check. Okay, so it's like just the case that the bank actually who is involved over there. Let's take the case that the A is a drawer of the instrument and further the instrument was given to person B. Now B person over here went to the bank XYZ. Now the bank XYZ bank is what? It is a collecting bank over here, and collecting bank is now involved in the process of the CTS over there, and also the clearing house will be involved in that. Now in that particular case the check, the physical movement of the check will be stopped by XYZ itself. It will be preparing the CTS clearing over here, and the electronic image along with the relevant data will be sent to the clearing house, and further then it will be cleared over there. So that is a process that will be taking place. I'll be letting you know each and every step in the process over there so that you can understand it in a better manner. Okay, so electronic image of the check truncated is actually substitutes what? It substitutes the physical check over there at that particular point, and further at the time of the truncation onwards over there. And for the truncation is done by during only the process of the clearing cycle to reduce the time taken for the realization. Particularly previously what happened that physical check was moving from one person or from one bank to another and further to the clearing house and then further to the paying bank over there, and that was a process that related to it. But now what happens that the actual check is retained by the collecting bank over here. The electronic image along with the relevant data is actually submitted to the clearing bank or clearing house over here, and from there the chart is prepared and further the paying bank is sent the data, and further also the electronic image along with the relevant data is sent over there. The details are being checked and the account of the person A will be debited and the credit will be given over here, and then it will be settled in the books of the XYZ bank over here. So that's the case related to it. So as to reduce the realization period, the CTS process is there. Now paper check after truncation, it is kept in the custody of the bank or the clearing house that truncated the check. So either the bank XYZ must have actually truncated the check, that the physical movement of the check has been stopped, or it could be the case that the clearing house over here could have actually truncated the check over there. Now in addition to that, the digital signature of the truncating bank or clearing house to the electronic image of the check truncation is optional over there, but it is quite necessary so as to add an authenticity and add an extra layer of the security to it. Okay, then let us understand the benefits of the CTS over here. Now first of all, as a foremost benefit, that the physical movement of the check is now actually not there. Okay, so it actually saves a lot of time to the bank, and further it's a significant cost saving to the bank also, and also it reduces the liquidity requirement of the bank because consolidation of the different clearing houses has been done. Like previously there were multiple clearing houses in different cities and states and districts over there, but now there are 4 clearing houses, and that is actually consolidated the data on a large scale that actually saves the liquidity of the bank also, and also it has eliminated the micro amount encoding, like you have to encode the micro amount over there. There are the resolution differences over there at both the micro and the image data travel now. Okay, so actually those differences have now been reduced over there, and further there is no risk because there is no physical movement of check, so there is no risk that the check can actually be lost, tampered, pilfered or anything, or the manipulation of the data could be related to it, because it cannot be done over there because the physical movement of the check is actually not there during the transit. Actually it enhanced their security and the automation system, and also from the customer point of view there is reduction in the clearing cycle over there, and actually it has lowered the risk from the customer point of view also, because the instrument now cannot be tampered and further cannot be lost in between the transit when it is moving from the collecting bank to the clearing house over there. And further, in case of need, the information, if it is required by the customer or it could be required by the paying bank over there, it can actually be taken easily over there. And also, as I told you that the check is truncated either by the collecting bank or by the clearing house. In that particular case now, the check is actually being kept in safe custody by the collecting bank or the clearing house which has truncated the check, and a true copy can be obtained if it is required. Okay, then further it's related to, there is a benefit of standardization. Now there is a uniform process which is taking place and the uniform practices which are taking place, so there is a benefit of the standardization. And further, the no outstation check collection charges are actually implemented when the CTS in the same grade is taking place. Like I told you that the whole country has been actually divided into 4 grades. Now whether you are from Punjab or Delhi, if it is under the same grade, in that particular case no outstation charges are to be imposed because it is in the same grade or in the same CTS clearing center over there where the clearing is taking place, so no outstation charges will be imposed on that. So those are the benefits related to the CTS. I hope that you must have understood the same. Now, as per the approach to CTS, the whole country has been divided into 3 grids, not the 4. It has been divided into 3 grids, and those 3 grids are northern, western, and further the southern grids are there. And further, each is having a separate clearing house located at Delhi, Mumbai, and Chennai. Like the northern clearing system is actually based upon Delhi, the western is based upon Mumbai, the southern is based upon Chennai over there. Okay, so that's the approach related to it. And now, who are the participants in this particular CTS clearing process over there? So there are 3 participants. One of it is related to the member banks who are the members of the clearing house. One of those are the sub-member banks who will be participating through the members over there. Like those are not directly the members of the clearing house over there. Like we are having the clearing house, and further ABC Bank is the member of the bank of the member of the clearing house over there. And further XYZ Bank is not a direct member, but it is operating through the ABC Bank over there. So that's actually related to what, that the XYZ Bank is not direct member over here, but it is operating through the ABC bank over here. Okay, the indirect members are actually those members who actually participate for submission of the data and images through a member bank, but will maintain a separate settlement account. Okay, so indirect members are actually related to what? That they are having a separate settlement account over here. The settlement is actually not taking place through the ABC. So now when the settlement is taking place for XYZ bank through the ABC, in that particular case it is a sub-member bank. And further, when actually XYZ bank is having a separate settlement account and settlement is taking place through that particular settlement account, but they are actually participating through the ABC bank who are members of the clearinghouse over here, in that particular case XYZ bank will be designated what? It will be designated as the indirect members over here. So that's actually the case related to it. Now let's understand the principles and practices of banking in CTS over there. Now banks actually need to transmit the clearing files. Now whatsoever the scanned checks we are having and whatsoever the data we are required to send to the clearinghouse over there, that will be sent through the clearinghouse interface. Okay, so there will be a clearinghouse interface through which the banks will be submitting the data. Like let's say that we are talking about the northern grid over there. Okay, in that particular case, whatsoever the banks actually there in the northern grid region over there, they will be actually collecting the data and further they will be scanning the checks over there, and after scanning the checks over there, they will be actually entering the data related to the checks over there, and further will be submitting that particular data to the clearinghouse through the CHI, that is a clearinghouse interfaces, or the DEM, that is a data exchange modules over there. Okay, now the checks drawn on the banks within the grid jurisdiction are cleared as local checks. Now let's take the case, as I earlier told you, that the multiple banks are there in a single grid. Now let's take the case that the Punjab and Haryana are under the same grid over there. Now in that particular case, whether the check is related to Punjab or it is related to Haryana, it will be actually be cleared as a local check, and it will be cleared on T+1 basis. T+1 basis means that if the check data is submitted today, the check will be cleared by tomorrow itself. Okay, and both the days are working days over here. Now let's understand the CTS process flow over here. It will get you to know that how actually the CTS work. So first of all, it's related to the presenting bank. Now for each of the check, there will be definitely be a presenting bank or branch over there which will be actually collecting all the data, which will be capturing all the data, and further they will be also scanning the check over there at the branch level or at the service branch level over there. Now once the data is consolidated, now that particular data will be consolidated on city level and town level, and then for the bank level itself for that particular grid over there, and further that particular information by the collecting bank. Now we are having the collecting bank over here. Collecting bank will be consolidating the data related to the checks over here, and that data will be consolidated on city level, state level, and further the country level bank over there and the grid level bank over there, and further that data will be submitted through the DEM or CHI, that is a clearinghouse interface, or the data exchange modules over there. That data will be submitted over there. Okay, so that's actually related to it. Then it's related to the presentation clearing over there. Now clearinghouse over here will be processing the data and arrives at the settlement figure. Now it would be the case that some of the checks are drawn on the other banks, and it would be the case that some checks are drawn on this particular collecting bank over there too. So that particular data figure will be, the net figure will be there, and the roots of the images and for the requisite data of the paying bank will take place in that particular case. Now let's take the case that the one check was drawn on bank ABC, that is a paying bank over there. Okay, now that particular image related to that particular check will be actually be transmitted to that particular bank over there. Now paying bank will be receiving the images and the data from the clearinghouse. Now clearinghouse interface will be actually be transmitting the data for that particular check. It could be the case that the collecting bank has actually going to collect the checks on ABC bank, on PQR bank, and so on. We are just talking about the ABC bank right now, that one of the check actually belong to ABC bank, which is the paying bank for the check over there. Now CHI will be transmitting the data related to check and further relevant data to the ABC bank, that is a paying bank over here, and further which is done actually on the same day. Like if the data is submitted to CHI on today, then the data from CHI to the paying bank over here there will be submitted the same day. Now paying bank will also generate the return file for unpaid instrument. Like let's say the instrument was not to be cleared. In that particular case, ABC bank will be preparing what? It will be preparing the return file. I'm just writing it over here because it's not clear. Okay, so it's a return file which will be prepared by the ABC bank, and that will be actually submitted again to CHI. Okay, now the return clearing actually is related to what? That I actually presented a check, but it is not to be cleared. Then the return clearing will take place. Okay, so the return file or data by the paying bank will be sent by the paying bank to the clearing house, and in return clearing session on the same way as the presentation clearing way. Okay, so that was the data when submitted to the CHI care by the collecting bank over there, that was the presentation clearing. Okay, and further, when the data has been submitted by the CHI to the paying bank over there, in that particular case the return file will be submitted. That is actually what, that is a return return clearing over there, and return data is provided for the processing purposes over there. Okay, so that's actually related to it. So return cycle is completed on the following day. Okay, now let's take the case that today it is T. So the data, that is a presentation clearing, will take place today, and the data will be forwarded to what? The data will be forwarded to the paying bank over there, but the return clearing will take place the next day over there. So that's the process related to it. I hope that you must have understood. Then further, it's related to settlement. Now, based upon all the instruments that have been actually accepted during a session, that session means what? Session means that there is a presentation cycle and further there is a return cycle. When actually that has taken place, now each bank will be clear about what the situation related to that, what checks have been actually honored and what have been dishonored over there. Okay, so that's actually related to closure of the clearing window over there. So for each of the bank over there is a single settlement of in the each grid over there. Okay, so for each of the bank in the single grid there is a single settlement. Okay, so banks need to maintain. Let's take the case that there is a collecting bank over there, and further they sent a check for the collection, and further the data was uploaded to CHI. The data is forwarded to the paying bank over there, and further the return is being filed on the next processing day over there, and the clearing cycle is actually completed. Now, the case is that the collecting banks and each and every bank is actually to maintain a current account with the Reserve Bank of India, and they are to maintain the liquidity over there. They are to maintain the sufficient balances over there in the current account with the Reserve Bank of India, so as to meet the daily settlement obligation over there. Now, clearing cycle is actually related to, there is a one presentation cycle and there is a one return cycle over there, and when it is all cleared, that is actually completing one clearing cycle over there. Okay, then it's related to the security feature. Now, because we are dealing with the financial data, the PKI system, that is the public key infrastructure, has been implemented in the CTS cases. Okay, and further it's related to endorsement. Now, at the time of scanning, a single line endorsement is printed on the back of each of the instrument with unique identifier for the instrument. Okay, now this instrument is actually to be endorsed over there. Now, that particular instrument is endorsed in single line and further with a unique identifier, so as to identify that particular instrument over there. Now, let's understand CTS differences for the bankers and the customers over there. Now, we must be keeping one thing in mind at the drawing bank, that the paying bank is actually paying the check based only upon the images over there instead of the physical checks. Now, it is crucial that we must be having a clear pictures and scanning related to these instruments, and further the physical movement is actually not available to the paying bank. Okay, so as to ensure the integrity of the system over there, the customers and the presentation banks must have new responsibilities related to CTS over there, which the customers must also be understanding. Okay, first of all, they must be using the CTS instruments on compliant instruments only, because other types of instruments leaves actually may not be providing the proper scanning of the images over there, and further so as to use the image friendly colored and the permanent ink over there, and also they must be writing clearly and legibly on the instrument, so that can be read easily by the concerned bank over there. Okay, because the images only are going to travel over there, and further all details must be written, like the beneficiary name, the date, and further the amount in words and figures over there, using the same pen and at one time only, and the amount in words is to begin with the word rupees, and that must be nearer to the word rupees over there, and without too much space, and further at end that must be usage of the word only over there. So that's actually related to precautions that are to be taken care by the customers over there, and there are additional precautions for the presenting bank too. First of all, they must ensure that the checks so deposited are CTS 2010 standards compliant checks only, so that there are proper images only and not the improper images must be avoided, and further they must be checking that all the details have been written properly on the instrument over there, because it could be the case that the details are not properly written and the check must be returned back. Okay, so that must be actually be avoided, and further they must be scrutinizing the check clearly, that if there is any material alteration, that must be detected by the presenting bank only, that is a collecting bank only. Okay, because previously the liability was actually related to what, like material alteration or anything, the liability was on the paying bank over there, but now there is no physical movement of the check and the check is truncated at the collecting bank and presenting bank only. Now in that particular case, it's a duty of the collecting bank so as to check the if there is any material alteration in that particular regard. Okay, now that particular responsibility of the paying bank is now transferred and shifted to the presenting bank under the CTS over there. And further, so as to ensure that the identification of its customer has been done properly, so as to mitigate the risk of fraudulent checks being deposited over there. So that must also be taken care by the presenting bank over there. Now let's understand the CTS check images over there. Now CTS in India is actually using a combination of the grayscale, black and white images over there. Okay, so three images of the checks are to be obtained. For the front side, the grayscale image is obtained, and from the back side, black and white, and for the black and white images is to be obtained. Like from the front side, we have to obtain two images, that is a gray and for the black and white, and further from the back of side of the check over there, the black and white image is to be obtained over there. So images of the checks are taken using the specific scanners only. The presenting bank has to digitally sign on the images of the checks over there, and further the data at the point of origin itself. Okay, so that the digital signs must be added to these scanned images over there when these images have taken the origin of these images have taken place. Okay, then it's the case of the CTS positive pay system. Now RBI actually introduced the positive pay system for the CTS purposes with effect from the 1st of January 2021. Now it's actually related to reconfirming the key details of the large value checks over there. Now, whensoever the large value check is being drawn, in that particular case, the key details related to check are electronically submitted. Like the minimum details related to data or what date is on the instrument over there, the name of the beneficiary or the payee over there, the amount, etc. These details are taken and further are actually passed to the dry bank, and further details of which are cross-checked with the presented check. Okay, now the paying bank, let me just tell you the through an inference over there, the details are actually submitted by the issuer, that is a drawer over here, will be submitting those details electronically to the drawee over here, that the drawee bank over there or the paying bank over here, and further these details are cross-checked with the check image which has been transmitted to the drawee bank over here. Okay, so that's the case related to the CTS positive pay system. Then it's related to RBI guidelines on collection of instruments. Now, first of all, it's related to that there must be immediate credit for local and outstation checks over there, and time frame must be decided related to the local and outstation instruments. And further, if there is delayed collection related to the local or outstation instrument, in that particular case, interest whatsoever will be paid by the bank over there, that must be decided, and that must be a policy must be there related to it, and that must be paid. Okay, so it's actually related to that the banks have been decided so as to reframe the check collection policies to include the compensation which will be payable by the bank itself on the daily interest rate that is to be paid by the bank to the person over there, to the concerned person over there, if there is delay in the collection of the instrument over there. Okay, and further the policy should be based upon the following broad principle. First of all, it's related to that there must be a comprehensive and transparent policy so as to cover the three aspects. Okay, then first of all, it's related to review their existing arrangements. We must be having the existing arrangements, we must be reviewing them, and further we must be working out a scheme that can actually reduce the collection period over there, and further there must be adequate care so as to ensure that the interest of small depositors are protected over there. So there are three aspects. First of all, it's related to immediate credit for local and outstation check over there, time frame related to collection of the local and outstation instruments over there, and interest payment in case of delayed collection is there. So these three aspects must be comprehensively be added to the policy, that is the check collection policy of the banks over there. So that's actually related to it. Okay, the policy should clearly lay down the liability of the banks, that what liability will be there if there is delay at the bank of the collecting bank over there, related to what interest payment will be paid to the customers if they are not complying with the standards which they have set for themselves in their CCP, that is a check collection policy over there. And compensation by way of interest payment should be made without any claim from the customer. So it should not be like that the customer must be raising the claim related to the delay of the checks will be to collected over there, but it must be paid automatically. Compensation by way of interest should be made without any claim from the customer itself. Okay, then it's related to collection of the account pay check. Now, under the law, actually it is prohibited, and also RBI has prohibited the banks so as to crediting the account pay check to the account of any other customer than the payee itself. Like let's say that the check was in the name of Shanti and further that the account must be credited, the amount must be credited in the account of Shanti only. Okay, the account, if the check was account pay in the name of Shanti customer over there, then the check amount so collected must be credited to the Shanti account only and not other than that. Okay, that is actually there so as to protect the banks from being burdened with the liabilities of unauthorized collection. Like let's say any other person visited and further the check related to the name of Shanti was actually be presented over there, the check was collected and it was actually collected in some other account. So it should not be done because it is against law and has also been prohibited by the Reserve Bank of India. And also it is there so as to maintain the integrity and soundness of the payment and banking system over there, and so as to prevent the recurrence of deviations observed that has been observed in the past over there. So account pay deposit checks must be deposited, must be actually collected in the name of that particular account name person only, in whose name the check has been drawn over there. Okay, so account pay checks deposited with some member for credit to their customer's account can be collected by the sponsor member bank of the clearing house. Now let me elaborate that particular point to you. Let's take the case that the ABC bank is here, which is a sub member, and further it is not directly taking place into the clearing house over there, and it is actually participating in the clearing house through bank XYZ over here. Now the check is actually in the name of Shanti and further has been presented to the bank ABC over here, but now ABC bank is actually not participating directly in the clearing house, the great clearing house over here. So the check is to be collected through the member bank, that is the XYZ bank over here. Now the check will be is cleared and further the amount is collected by the XYZ bank over here. Now the credit will be passed on to ABC bank. Now in the books of XYZ bank, the account is not credited related to Shanti over here, it is credited to the bank account over here. So that is actually allowed in that particular case over there. I hope that you must have understood. And further, so as to mitigate the difficulties faced by the members of cooperative credit societies, now let's take the case of the cooperative credit societies. In that particular case also, there are multiple and numerous members which are actually associated with the cooperative society over there. And further, let's take the case the check related to cooperative society is being produced and further given to this particular ABC bank over there, and further that can also be collected up to a limit of rupees 7,50,000 over there. And further RBI has actually advised this particular case that this can be considered in case of the cooperative credit societies, that the account pay checks which have been actually produced, which have been actually presented by the cooperative society over here, cooperative credit society over here, that particular check can be collected up to the amount of rupees 7,50,000 to the accounts that the cooperative credit societies have been maintaining. Okay, so that's actually related to it. But let's take the case that the check related to the Shanti over here, which is a constituent and which is a member of this cooperative credit society over here, has been presented by the cooperative credit society to the ABC bank over here. In that particular case, the account can be credited. The account can be credited of cooperative society, whether the check was in the name of Shanti over here, but it has been actually been presented by cooperative credit society over here. The amount allowed is rupees 7.5 lakh. That up to this particular limit, if it is in the name of the constituent member of the cooperative credit society, it can be actually collected and further be credited into the name of into the account of cooperative credit society over there. There is related to the checks instruments lost in transit in clearing process at the paying bank branch over there. Now there can be the instances over there where the checks lost in transit or in the clearing process over there or at paying bank's branch over there. Now in that particular case, the bank must be taking immediate steps over there. The bank must be immediately informing the account holder. Now first case it's related to, let's take the case that the A person over here has actually presented the check, but it is now lost. Whether it is lost in the transit over there, whether it was lost in the clearing process over there, whether it was lost in at the paying bank's branch over there, that is actually not possible in case of CTS, but definitely it can be also be the case that the check was actually given for presentation to the bank ABC over here, but ABC before presenting the check has actually lost the check over there. In that particular case, ABC bank will be actually informing this particular case immediately to the account holder over there, so that they can actually informing the drawer over here. They can actually inform the drawer over there. And also it could also be the case that A must have actually issued further checks. Now those checks also will be dishonored because amount which the A was actually anticipating that will be credited to the A's account over here is not now going to be credited over there because that instrument is lost. So that information must be immediately provided to the person A, that is the account holder over here, that your instrument is now lost over there. Okay, and the onus of the loss actually lies on the collecting bank over there and not on the account holder, because it is a collecting bank which has actually lost the instrument. So whether the instrument is lost at the collecting bank, whether in the clearing house over there, or whether at the paying bank branch over there, the honors actually lies on the collecting bank over there. So bank should reimburse the account holder related expenses, like if they want to obtain a duplicate check over there, so whatsoever the expenses over there, those are to be compensated by the collecting bank over here. Okay, and further, if the check and instrument has been lost on the paying bank branch, if the check has been lost on the paying bank branch, the collecting banker should have a right, like if the collecting bank is ABC and further the paying bank is XYZ bank over here, and further the instrument was lost by the XYZ bank over here, first of all ABC bank will be compensating, and ABC bank will be having a right that they can actually ask for compensation from the XYZ bank over here, that is the paying bank over here, if the instrument is lost at the paying bank's branch over there. So that's the case related to the same. Now it's related to the bills for collection. Like the checks are sent for collection, it is also the case that the bills may be sent for collection, whether those are discounted or sent for the collection purposes over there. And further, in that case also there can be a delay. And further, if the lodger banks, the delay is from the lodger bank, let's take the case that the ABC is a firm over here which is having a bill in its name, and further that is actually presented to the bank XYZ over here for collection purposes. Now actually there is a delay at the XYZ bank, and it's actually the delay in collection is there. Now in that particular case, XYZ bank is what? It is a lodger bank over here to whom the instrument has been lost for the collection purposes over there. So in that particular case, if the delay is there for the collection over there, so for that particular case, the 2% per annum interest rate, the interest is payable by the lodging bank to the party over there in their saving bank account. Okay, so whatsoever the saving bank balance is, interest rate is there, plus 2% per annum interest rate, that is to be actually paid for the delayed period to the ABC party over here. So that's the case related to it. I hope that you must have understood the same. Now let's move to the next part. It's related to the cash and its custody. Now particularly the cash and whatsoever the small coin balances are there, they must be kept in the strong room under there, and further those must be under the joint custody of the head cashier and the cashier over there, and manager must be the in charge related to the joint custody over there. And further, no member of the staff other than the cashier and the teller services receives the cash over the counter from the depositors over there. So it's none of the other persons are having the right related to depositing the cash or receiving the cash. Okay, so note counting machines must be provided so as for a quicker handling of the currency notes over there. Now let's understand related to the strong room and safe. So there must be a strong room and further must be a safe over there, which must be under the dual custody of the head cashier and the cash officer over there, and the manager is the in charge of the cash over there. So both the official must be present over there when the strong or safe is opened, right? And further it's related to cash balance of the bank. So bulk of the cash balance must always be in the strong room or under the safe under the joint custody over there, while the remainder, like for day-to-day correction, for day-to-day transaction purposes, let's take the case that the branch balance was rupees 40 lakh. In that particular case, let's say 30 lakh is actually maintained in the safe strong room over there or safe over there under the joint custody, and further the rest of balance is maintained with the head cashier and the cashier over there for day-to-day transaction purposes. Okay, then it's related to the checking of cash balances. So before taking notes and coins into the joint custody balance, the supervising official will check the correctness of the denominations so mentioned on the cash book over there. Then it's related to shortage or excess in cash. So whether it's the case of shortage or whether there is excess of cash, that must be reported over there. So system of recording denomination wise number of the pieces of the currency notes must be there for every of the receipt and every of the payment. Now whensoever the payment is made, there is a denomination that must be noted down, and further whensoever we are receiving the payment also, there the denomination must be noted down over there, both on the voucher and on the cash register as well as there. Okay, and further it's related to when there is shortage or excess of cash. Now when there is shortage of cash, that must be recovered from the cash officer, the concerned cash officer, or the head cashier over there, or the cashier over there, who will be in return will be recovering from the concerned employee over there. Okay, and further failing if there actually the cash shortage is there, and further there is no recovery from the concerned person over there, in that particular case the amount must be debited from the suspense account taking the signature of the concerned employee who is responsible for the shortage of cash over there. Let's take the case that the person A was given responsibility related to cash and there was shortage shortage of rupees 500. Now this 500 are to be basically recovered from person A. Now if the recovery is not there, in that particular case, on the same day if the recovery is not there, in that particular case a debit voucher will be posted to the suspense account, and the signatures of A must be taken on that particular voucher over there, and subsequently after that the amount is to be recovered from that particular person over here. Okay, and also if there is excess of cash in that particular case also, whatsoever the excess amount is there, that must be credited to the sundry deposit account on the same day itself. And if a customer makes a complaint of having received a cash in short, or must have paid the cash in excess over there, for after satisfying about the genuineness of the complaint over there, the amount must be debited. Now let's say the case that the excess of cash was rupees 1500 was there. Now that particular amount must be credited to the sundry account over there. And further, if a customer lodged a complaint, so it could be the case first of all that he had made a payment. Let's say the case we are taking the from the customer point of view, that he actually has withdrawn the money and he received rupees 1500 short. Okay, it could be the case, or it could be the case that the customer has deposited the amount and further he actually deposited rupees 1500 in excess over there. In both the cases, if the customer has lodged a complaint and if the complaint is genuine enough, after satisfying about the complaint of the customer, the amount must be debited from the sundry account over there where the excess cash was kept over there, was credited over there, that must be paid to the customer. Okay. The next point, it is related to remittance of cash. Now, when the cash is to be remitted from one office to another or from one branch to another, it is always entrusted to employees over there, and night journeys and unusual halts at the junctions must be avoided. And further, the remittance box must always be transported in a van that is provided by the bank over there, and box in which the cash is actually kept over there must be securely chained and further locked to another fixed object in the van over there, and register must be maintaining the record of all the cash remittances from that particular branch to other branches over there, so that those precautions are to be taken. And it's related to cash replenishment at the ATMs over there. Now ATM machines must be filled with adequate amount of cash over there. That is important so as to avoid the cash out situations, and there must be uninterrupted services, those must be provided to the customers over there. Now staff whosoever is involved in the cash replenishment over there, they must be thoroughly checked and further must be thoroughly screened, and the photos and biometric prints must be taken at each and every point over there. Then it's related to insurance. Now all the cash remittances in transit must be covered with the bank insurance policy, and each and every bank is actually having insurance up to some particular point. Let's say the case that the bank is having a cash and remittance policy for up to amount which is covering amount up to rupees 50 lakh. So in no case without the permission, a written permission from the regional office or the zonal office, the cash in remittance amount must not be exceeding rupees 50 lakh, because the insurance is available up to rupees 50 lakh only, and that must be taken care of. Okay, then further it's related to custody of keys. Now particular of all the important keys, whether it's the cash key, strong room key, or the safe key over there, that must always be registered, that must always be entered into the key register, and all the details related to the original keys and for the duplicate keys must be mentioned therein. And further, in case of safes previously handled by unauthorized officials over there, those locks and levers must be changed over there. And if there is any need related to repair of those locks over there, that must always be carried out in the supervision of manager and the cash officer, head cashier and cashier under the joint control. Okay, and whenever a lock is changed or the levers of the locks are changed, it must be noted in the key register over there. Then it's related to duplicate key. Now actually there are two sets. One, it is related to original set, and the other one, it is related to duplicate keys. Now the details are to be entered into the key register. All the details, whether it's related to the original keys or the duplicate keys, those must be entered into the key register over there. And further, the rotation related to the keys must be there at least once in a year. And further, the duplicate keys, after packing them and further sealing them into a white cloth and into the waterproof cloth over there, and within a good and hard box over there, those must be placed at some other branch in that particular locality only. Okay, so the sealed pockets must be placed in strong wooden or tin box over there, and those must be locked and must be otherwise secured over there, must be wrapped with the waterproof cloth over there, and the cloth must be sealed over there. And further, those are to be kept in some another local branch of the same bank or of some other bank over there. Okay, so duplicate keys must be withdrawn from the safe custody and must be rotated at least once in a year. Okay, then it's related to security measures that must be kept into view in the branches and the ATMs over there. First of all, it's related to location and layout related security measures. So the location of the branch must be chosen keeping in the safety and security in view. Okay, so the branch must not be on the outskirts, so it should be basically the police authorities should be consulted before deciding a branch location over there, whether there is proper patrolling over there, and it should be in proximity to the police station over there. And further, the layout of the branch must also be in such a way that whatsoever the cabins, whether it's a manager cabin, cash vaults, or a strong room over there, those must be kept in view from the security point of view. Then it's related to protective fittings related. Now there must be shutter gate on the main entrance, and there must be a collapsible gate with a chain over there, locking arrangements must be there, and there should be only 8-inch opening in the collapsible gate over there that must be fitted in the entrance of the branch over there. So strong rooms must be having the grill gates between them, and further the windows, ventilators should be having a proper standard grill over there. Unnecessary windows should be walled, and that is the major thing related to the protectiveness related over there. And then it's related to electronic security gadgets. Nowadays a lot of security gadgets are available, like we are having the CCTVs, we are having the X-ray scanners, we are having the electronic locks, we are having the hotlines, we are having the auto dialers. Those must be used so that we can actually safeguard our branch. Okay, so these devices actually help in reducing the delay in communication to the police and further identifying the culprits so that we can catch them easily. So, and also the emergency lights and alarms must be installed and should always be in working condition. So fire protection also must be there. There must be adequate number of the fire extinguishers that must be available, and there must be a routine fill up of those, refilling of those instruments, extinguishers over there. And also there must be smoke detectors. Those should be fitted at the various points over there. And then it's related to security guard related. So posting of the security guard must be decided based upon the vulnerability of the branch. Now if we consider that the branch is situated at a high risk, in the high risk location or area over there must be armed guards which must be there. Other than that, we can go for the normal guards also. Okay, so the currency chest branches must be having at least 2 armed guards during the working hours and 1 armed guard around the clock over there. So that's actually the criteria related to the security guards over there. Then it's related to firearms related. Now firearms should always be in the working condition. All the armed guards must be cleaning and maintaining the guns regularly so that they can remain in the working conditions over there. Now let's learn about the currency chest specific measures over there. Now security arrangements in the currency chest should meet up with the security standards over there. Those are actually issued by the Banking Division, Ministry of Finance, Government of India over there. So first of all, there must be installation of the steel barricades. The currency chest area must be segregated from the branch hole. Like in most of the cases, what is there, that the branch is in the upper area and further the chest area is segregated over. So that thing must be maintained, and further there must be barricades and must be installed over there. So positioning of armed guards must be on duty in front of the currency chest over there. As I told you that in case of currency chest, there must be 2 armed guards during the working hours, and further 1 armed guard must be available 24/7 over there. Okay, and then it's related to payment and movement of large or bulk cash. So whensoever there is payment of large amount of cash that is to be made, and in that particular case the payment is to be made inside the strong room or enclosures only, and also always be away from the public view. Okay, then it's related to the counterfeit notes. Now counterfeit notes are related to the fake currency notes which are there in the circulation, and in no case no credit must be actually be given to the customer's account. Like if person A has deposited a counterfeit currency note over there, in that particular case no credit must be given to the person A account over there if the counterfeit currency note is detected over there. Okay, and further it should not be returned. It should not be returned to the tender over there. It should not be destroyed over there. These must be stamped as counterfeit note over there and are to be impounded and not to be given back to the customer over there. Now incident of detection of the counterfeit notes are to be reported to the police as per the rules available over there. So now if the transactions are actually involving 4 pieces of counterfeit notes over there, now I'm telling you that if the transaction is involving 4 pieces of counterfeit notes over there, in that particular case a consolidated detail must be actually be maintained in a prescribed format over there, and that must be sent by the nodal bank officer to the police authorities. That must be sent to the police authorities or to the nodal police station along with the suspect counterfeit notes over there at the end of the month, if the 4 notes of the 4 pieces are actually detected in one transaction over there. And further further, for every transaction which is involving 5 or more pieces of the counterfeit currency, in that particular case, FIR on prescribed format with the counterfeit currency must be filed immediately by the nodal bank officer with the local police authorities. Okay, so in that particular case, when we are having the 5 pieces of fake currency notes with us, in that particular case, immediate FIR is to be actually be lodged with the by the nodal bank officer with the local police authorities over there. A copy of the monthly consolidated report or FIR must be sent to the vigilance cell at the head office over there. So that's actually related to the counterfeit currency and all related to the operational aspects on the handling of the clearing houses.